Once again, I'm Patrick Smith. I'm the president of the Intellectual Property Institute of Canada. I'd like to thank this committee once again for inviting IPIC to present to you our thoughts today on Division 7 of Bill C-86. Specifically for the next few minutes, I will address our recommendations on the enabling legislation for the College of Patent and Trademark Agents, including Subdivision D of Division 7. I'm also happy to answer any questions you may have. As I mentioned during the previous panel, IPIC is the Canadian Professional Association of Patent Agents, Trademark Agents, and Lawyers practicing in intellectual property. Not only do we represent the views of Canadian IP professionals in our many submissions to government, but our activities also include offering education and continuing professional development, raising IP awareness in the business community, and for the past several years, creating a voluntary code of conduct for the profession to follow as a condition of membership to the Institute, or in the Institute. We're very happy to see the government move ahead with the enabling legislation for the college in Bill C-86. IPIC, as many of you may know, has been advocating for the need for a self-regulatory governance body structured like those of most other long-standing professions in Canada, and we've been doing that for over 23 years. I think it's important to mention that we are not seeking regulation because there are major issues or that members of our profession are facing many complaints. Patent and trademark agents form a profession with a tradition of excellence, and the Canadian Intellectual Property Office, with the assistance from the profession, administers rigorous qualification exams. However, the regulatory framework is incomplete. Although IPIC offers many of the components required in a regulated profession on a voluntary basis, there is no mandatory code of conduct. There's no continuing education requirement or discipline process. Our desire is for the Canadian intellectual property profession to be recognized and trusted like the other professionals, such as engineers, accountants, and lawyers, who are governed by a self-regulatory body. This increased level of trust will encourage more Canadian small businesses to take the necessary steps to protect their intellectual property and include IP as an important part of their business planning. We believe the creation of a college is critical to doing just that. IPIC's Professional Regulation Committee has been looking over the legislation in great detail since it was tabled on October 29. We will be providing a fulsome submission next week on suggested improvements to the legislation, but have identified a few issues that we felt warranted a discussion with you today. And I can assume that by next week we're going to do it as soon as we can?
Yes.
So the first relates to sections 70 and 71. These sections, in essence, establish who may represent individuals before the Patent Office and Trademarks Office. Both ISED and IPIC are in agreement that the status quo should be maintained. The reference to legal counsel in sections 70 sub 2 and 71 sub 2 on their own may suggest that it was intended that lawyers who are not qualified to practice as patent agents or trademark agents may nevertheless represent individuals before the Patent Office and Trademark Office. This is prohibited by the current Patent Act and related patent rules, which states that only qualified patent agents may represent individuals before the Patent Office. The same goes for trademarks. This legislation also repeals the sections of the legislation that require you to be a patent and trademark agent to represent applicants in presentation and prosecution of applications. Although we understand from the government that there's no intent to allow lawyers who are not qualified patent agents or trademark agents to make representations before the Patent Office or Trademarks Office, we do believe that the way these sections are drafted currently, or the proposed draft, is problematic as it relies that they remove the legislative requirement to be a patent agent or trademark agent to represent a client in the prosecution of an application, and instead rely solely on the requirements and the regulations. We feel this may open up the college and government to future challenges by non-agent professionals. It also weakens the public protection for Canadian businesses that their representative must be a qualified agent to prosecute their application for IP rights. In view of the potential confusion that the current wording may create, as well as the weakening of the statutory requirement, it is recommended that sections 70 and 71 be amended to remove any potential misunderstanding. Our second issue pertains to section 33 sub 1 of the college legislation, which requires the inclusion of the code of conduct in regulations. We see the code of conduct as a living, breathing document, and given the rapid pace of change in the innovative industries and the IP profession as a result. We believe that it is very problematic for the code to live in the regulation. Although it is not completely unprecedented, it is extremely rare for a profession's rules of professional conduct or code to be written into regulation. In almost all cases in Canada, where the code is very complex to reflect the multifaceted nature of the work being conducted by a profession, the code is created by the bylaws by the college as approved by their board. And I may remind the committee that there are provisions that require ministerial approval of changes to the code, and also that establish a majority of public seats on the college's board who are appointed by the minister himself. Our recommendation is to incorporate the code by reference in the regulations, but allowing the code to live outside of the regulations. The code may be deemed to be a regulation under the Statutory Instruments Act, but that act allows it to exist as a bylaw or some other form outside the actual regulations, as it would be considered for the purposes of that act to be a regulation. This structure will allow the college to amend the code efficiently and be a responsive organization to trends and changes in the innovative industries and in the public interest. To give the committee a point of comparison, we've looked at what the Law Society of Ontario has done regarding their code of conduct. The rules of professional conduct are not actual regulations under the Law Society Act. The benchers, the LSO's board, oversee and approve the rules of professional conduct, but the rules are not actual regulations under the Law Society Act. Rather, the authority to make the rules and bylaws comes from the Law Society Act by way of legislative delegation. Thank you for inviting IPIC to represent or to present to you our comments today. And if there's any questions, we'd be happy to address them.
Thank you very much. That's